Okay, the floor is yours. Senator Harris.
Thank you, Mr. Chairman. First, I want to extend greetings to Judge Barrett, and I look forward to our conversation this evening.
Thank you, Senator.
Thank you. Before I begin, I want to just take a moment to talk directly with the American people about where we are and how we got here. So we are in the middle of a deadly pandemic that has hit our country harder than any other country in the world. More than 215,000 of our fellow Americans have died, and millions more, including the President, Republican members of this committee, and more than 100 frontline workers here at the Capitol complex have been infected. This pandemic has led to an historic economic crisis, causing millions of workers to lose their jobs without warning, and 12 million Americans have lost their employer-based health insurance. The Senate, I strongly believe, must be and needs to be laser-focused on you, the American people, to help you get through this pandemic. To do so, the Senate urgently needs to pass critical financial relief for those who are struggling because of this pandemic, and many are struggling. People need help. They need help to pay their rent or mortgage. Parents need help putting food on the table. The millions of American workers who have lost their jobs need help making it through the end of the month. And small businesses need help so they don't have to close their doors for good. But sadly, Senate Republicans have rushed to hold this Supreme Court confirmation hearing rather than help those who are suffering through a public health crisis not of their making. As I said yesterday, these priorities are not the American people's priorities. Since President Obama signed the Affordable Care Act into law, Senate Republicans' #1 priority has been to tear it down. And remember, before the ACA, the Affordable Care Act, insurance companies held virtually unchecked power over our healthcare system. They could refuse to cover basic medical expenses like maternity care, like mammograms, like prescription drugs, or hospital stays. Worst of all, if you were sick, they could deny you coverage altogether, and there was nothing you could do about it. Over the last 9 years, Republicans in Congress have tried 70 times to repeal or roll back the ACA in the United States Congress. In 2013, Senate Republicans were so desperate to stop its success that they shut down the entire government for weeks. After President Trump was elected, Washington Republicans spent nearly a year trying to repeal the ACA. But I will always remember the thousands of Americans from all over our country and all walks of life who crowded into the halls of the United States Capitol to require that lawmakers see their faces and understand how they would be hurt if there was a repeal of the Affordable Care Act. Brave activists in the disability community staged sit-ins on the Hill. Seniors protested to keep prescription drugs affordable. Mothers and fathers walked the halls with their children in strollers to show Congress the face of those who depended on the law, and doctors and nurses protested to protect their patients' access to the care they desperately need. Together with many of my colleagues, I joined civil rights and community leaders to speak to the thousands of people who gathered outside the Capitol as they pleaded, as they begged with lawmakers to do the right thing. All of these dedicated Americans demanding that their voices be heard. And they made a difference. They made a difference. History will remember that late night, thumbs down movement when the great John McCain denied Republicans the opportunity to repeal the Affordable Care Act. And now, following a decade of failure, Washington Republicans have realized that the Affordable Care Act is working too well and helping too many people to repeal it without facing serious political consequences. But what are they doing? After suffering the backlash that they provoked by targeting the law in Congress, they decided instead to circumvent voters and try to strike down the Affordable Care Act through the courts. Right now, the Trump administration and Senate Republicans are urging the Supreme Court to strike down the entire Affordable Care Act and all of its patient protections. Republicans are scrambling to confirm this nominee as fast as possible because they need one more Trump judge on the bench before November 10th to win and strike down the entire Affordable Care Act. This is not hyperbole. This is not a hypothetical. This is happening. And here's what you have to know. People are scared. People are scared of what will happen if the Affordable Care Act is destroyed in the middle of a pandemic. There are more than 100 million Americans with pre-existing conditions like asthma and diabetes, heart disease, who know that they could be denied coverage, are charged more by insurance companies if Donald Trump is successful in getting rid of the Affordable Care Act. And because of the coronavirus, more than 7 million people have now a pre-existing condition that they didn't have earlier this year. Those who depend on the ACA are afraid of their lives being turned upside down if the court strikes it down. They know what could happen. And Judge Barrett, I will share with you and the American people a list. No protections for pre-existing conditions, higher costs for health care for women and people over the age of 50, young adults kicked off their parents' insurance, more expensive prescription drugs for seniors, insurance companies refusing to cover mental health care, insurance companies refusing to cover maternity care, no free mammograms, cancer screenings, or birth control, insurance companies reinstating annual and lifetime caps, and more than 20 million Americans losing insurance at the worst possible time, again, in the midst of a pandemic, including nearly 2 million Texans, 607,000 North Carolinians, 288,000 South Carolinians, 227,000 Iowans, and 4.2 million Californians. And the pain of losing these protections would disproportionately be felt among the 9 million African American, Latino, Asian, and Native Americans who gained coverage under the Affordable Care Act. But this isn't about statistics. This is about millions of real people living real lives who deserve their government and its institutions to see them and to heed their call. And I know a Republican member of this committee said earlier today that the people who will lose health care are somehow not relevant to this hearing. I disagree. Helping these people is supposed to be why we are all here, why we all ran for office in the first place. And I'm here to fight for people like Felicia Perez. And this is her. Felicia is a writer, a public speaker, and former high school teacher from Southern California who now teaches at the University of Nevada, Reno. She has multiple pre-existing conditions, including arthritis, asthma, and a rare autoimmune disorder that caused tumors that have wrapped around her optic nerve and part of her brain. Her life depends on periodic cancer-fighting infusions that cost $160,000 a year. Felicia is terrified. She knows that without the Affordable Care Act, she could not afford ongoing treatment, the treatment she needs to stay alive. And here's exactly what she said, and I will quote. "My life is in the hands of people I do not know, who do not know me, who are essentially telling me I don't matter, that my life doesn't matter, that my health doesn't matter, that the day-to-day quality of my life doesn't matter. And that's really hard." Tragically, Felicia's story is not unique. Her fears are shared by millions of Americans. The Affordable Care Act and its protections hinge on this Supreme Court and the outcome of this hearing. Before being elected, President Trump promised that every justice he put forward would, quote, will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare, unquote. Judge Barrett, 18 months later, you criticized the Chief Justice for upholding the Affordable Care Act when you concluded, quote, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. My question is, how many months after you published that article did President Trump nominate you to be a judge on the Court of Appeals?
Senator Harris, I apologize. I don't remember the timing of that article. I was nominated, I believe my nomination to the Court of Appeals was announced in May of 2017.
That's correct.
But I don't remember when the article came out.
The article was published in January of 2017, so that would have been 5 months later. Justice Ginsburg, whose seat you are seeking to fill, provided the critical fifth vote in a 5-4 decision that upheld the Affordable Care Act. So let's lay this out for everyone who's watching. As I've discussed previously, 1, Republicans have spent a decade trying to destroy the Affordable Care Act. 2, Donald Trump promised to name a Supreme Court justice and Supreme Court justices who would tear down the Affordable Care Act. 3, President Trump is before the Supreme Court right now arguing that it be struck in its entirety. 4, the Supreme Court could be just one vote away from overturning the Affordable Care Act and all of its protections, including for everyone who has a pre-existing condition or may ever get a pre-existing condition. In other words, the Affordable Care Act and all its protections hinge on this seat and the outcome of this hearing. And I believe it's very important that the American people understand the issues at stake and what's at play. Judge Barrett, the day after President Trump announced your nomination to the Supreme Court, he tweeted, quote, Obamacare will be replaced with a much better and far cheaper alternative if it is terminated in the Supreme Court, end quote. But in reality, there is no alternative that protects the millions of Americans who depend on the Affordable Care Act every day. The horrifying truth is that President Trump and the Republicans in Congress are fighting to take health care away from the American people in the middle of a pandemic, as I have said. President Trump has said that he wants to protect the American people's health care. But the reality is right now, he is asking the Supreme Court to take it away, period. Senator Klobuchar, Judge Barrett, asked you earlier today, but did not receive an answer. Prior to your nomination, were you aware of President Trump's statements committing to nominate judges who will strike down the Affordable Care Act? And I'd appreciate a yes or no answer, please.
Well, Senator Harris, I want to be very, very careful. I'm under oath. As I'm sitting here, I don't recall seeing those statements, but let's see, I don't recall seeing or hearing those statements, but I don't really know what context they were in, so I guess I can't really definitively give you a yes or no answer. What I would like to say is I don't recall hearing about or seeing such statements.
Well, I imagine you were surrounded by a team of folks that helped prepare you for this nomination hearing.
I have
Did
had,
they,
yes.
but let me finish if you don't mind.
Oh, I'm so sorry.
Did they inform you of the president's statements and that this might be a question that was presented to you during the course of this hearing?
When I had my calls with senators, it came up. Many of the Democratic senators wanted to know about the Affordable Care Act and to satisfy themselves that I had not made any pre-commitments to the president about it.
And so you then became aware of the president's statement, is that correct?
Let's see, Senator Harris, in the context of these conversations, I honestly can't remember whether senators framed the questions in the context of President Trump's comments, perhaps so. I think from my perspective, the most important thing is to say that I have never made a commitment, I've never been asked to make a commitment, and I hope that the committee would trust in my integrity not to even entertain such an idea, and that I wouldn't violate my oath if I were confirmed and heard that case.
So just so I'm clear, and then we can move on, are you saying that you are now, before I said it, aware or not aware that President Trump made these comments about who he would nominate to the United States Supreme Court?
All right, Senator Harris, what I was saying, I thought you initially framed the question as whether I was aware before this nomination process began. And my answer to that question...
I'm now asking you if you are aware, were you aware before this hearing began?
So you're changing, you're asking me now whether I was aware before the hearing began?
As a follow-up question, I am, yes.
And what I said was that when I had my calls with Democratic senators, this question came up, and I don't recall, but it may well have been that they referenced those comments in the course of those calls. Even if so, that wasn't something that I heard or saw directly by reading it myself.
Senator Leahy asked you earlier today, but I think it bears repeating. Do you think it is important for the American people to believe that Supreme Court justices are independent and fair and impartial? And that is a yes or no answer, please.
Yes, Senator Harris.
A number of my colleagues have asked you today whether you would recuse yourself from cases on the Affordable Care Act. You did not directly answer their questions, and instead you described a process by which that would work or happen. And so my question is, isn't it true that at the end of that process, regardless of that process, that it would be you who ultimately would make the decision about whether or not you would recuse yourself?
That is true, and I can't have you elicit a commitment from me about how I would make that decision in advance. That would be wrong.
Right, and what I've asked you is that, is it not correct that that is the process, that ultimately it would be you and you alone that would make the decision about whether you would be recused? You've already opined on the constitutionality of the Affordable Care Act, and that position satisfied the president's promise to only nominate judges who would tear down the Affordable Care Act. And Senate Republicans rushed this process so that you could rule on this very case. The reasonable question about your impartiality will undoubtedly hang over this court's ultimate decision in the Affordable Care Act case if you refuse to recuse yourself. I strongly believe that. Supreme Court justices routinely consider the consequences of their decisions on people's lives. Earlier this year, the Supreme Court ruled against President Trump in his effort to repeal DACA protections for Dreamers. Children, of course, who have arrived in the United States, many before they could talk or walk. Chief Justice Roberts wrote the opinion for a 5-4 majority that included the crucial vote of Justice Ruth Bader Ginsburg. The court rejected the Trump administration's attempt to end protections for Dreamers. Chief Justice Roberts said the administration had not taken into consideration the fact that many Dreamers relied on those protections when they started their careers and businesses, when they served in the military of the United States, when they bought homes, and when they started families. Senator Hirono asked you whether it is appropriate for a Supreme Court justice to consider real-world impacts. But you're a sitting judge now. So my question is, in deciding whether to uphold government action, do you currently consider the consequences of your rulings on people's lives?
Well, Senator Harris, that's part of the decision of every case.
And so you do?
Every case has consequences on people's lives, so of course I do in every case. That's part of the judicial decision-making process.
And would you do that as, if you are actually voted on the United States Supreme Court? Would you do that there as well?
Senator, considering how the resolution of a dispute will affect parties, will affect people, is part of the judicial decision-making process, and I will continue engaging in that process to the best of my ability.
So if the Affordable Care Act is struck down, more than 100 million Americans with pre-existing conditions like heart disease, diabetes, and cancer would pay more for insurance or be denied coverage entirely. more than 20 million Americans could lose their health coverage entirely, including nearly 3 million Black Americans and over 5 million Latino Americans who received access to health insurance because of the Affordable Care Act. Insurers will once again be able to discriminate against that more than 50% of African Americans and nearly 40% of Latinos with pre-existing conditions. Insurers will be able to deny coverage to more than 1/4 of Native Americans with conditions like diabetes, heart disease, and cancer. All of this in the midst of a pandemic that is not going away anytime soon. A pandemic that, when age is taken into account, has been 3 times as deadly for Black, Latino, Pacific Islander, and Native Americans. A pandemic that has killed approximately 1 in 1,000 Black Americans, 1 in 1,200 Native Americans, and 1 in 1,500 Latino Americans. Judge Barrett, would you consider the 135 million people who gained protections under the Affordable Care Act when deciding a case that challenges that law?
Senator Harris, if I were to be confirmed and conclude that I was able to sit on the case pursuant to the recusal statute, and then if I heard the case and decided the case, I would consider all the protections that Congress put in place. And as I said earlier during this hearing, the question would be figuring out whether Congress, assuming that the mandate is unconstitutional now, whether that, consistent with your intent, this is Congress's law, would permit this act to stand, or whether the flawed portion of it could just be excised out. And that is a question not of what judges want. It's not a question of the Supreme Court. It's a question of what Congress wanted in the statute. And that is the statute, that you enacted and extended this health care coverage to millions of Americans.
What weight would you give the fact that 135 million Americans with pre-existing conditions are now depending on the protections of the Affordable Care Act? What weight would you give that?
Well, Senator Harris, as I mentioned to Senator Hirono, stare decisis takes reliance interests into account because, as I've said before, stare decisis is about keeping stability in the law. So the law often takes into account reliance interests. I can't really say, sitting here, how they would play in or weigh in this case, because that's part of the legal calculus of the case. So I can't really give you the kind of commitment or pre-commitment that you're asking from me of how I would weigh factors or how I would structure my decision-making process.
I would ask you to consider, if you are confirmed on the court, a credible benefit of the Affordable Care Act, and that a destruction of its protections will have a devastating impact on millions, hundreds of millions of Americans. Judge Barrett, you testified yesterday that Justice Ruth Bader Ginsburg opened the door for many women in law. And I certainly believe and know that to be true as a personal matter. She was a trailblazer for women's equality and gender equity. As a law student, as a teacher, as a civil rights lawyer, and as a second woman ever to sit on the United States Supreme Court, Justice Ginsburg broke many barriers for women across the country. I believe, all fondly remember her as a person who had patience. She had the will and the vision to make our country a more equal place and a more just place. And one of the things she fought for was a woman's right to control her own body and to make decisions about her own body and health care and reproductive choices. The Constitution of the United States protects a woman's right to choose whether or when to become a parent. And it protects a woman's right to choose abortion. Women of color, immigrant women, women with low incomes, and women in rural areas face significant barriers when attempting to access birth control, cancer screenings, and comprehensive reproductive health care. Moreover, anti-choice activists and politicians have been working for decades to pass laws and file lawsuits designed to overturn Roe and the precedents that followed. The threat to choice is real. Just last year, the court heard a case that gave it an opportunity to revisit and overturn its abortion precedent. In a case called June Medical Services, the Supreme Court struck down a medically unnecessary restriction that would have closed all but one abortion clinic in Louisiana. Chief Justice Roberts agreed with the court's 4 liberal members that the court was bound by its own precedent to strike down the Louisiana law because it was virtually identical to a Texas law that the court ruled unconstitutional in 2016. As a result, women in the state were able to receive the full range of reproductive care. But Chief Justice Roberts wrote his own separate opinion in the case to make clear that in the future he could not be counted on to uphold a woman's right to choose. Justice Ginsburg provided the critical 5th vote to strike down the unconstitutional abortion restriction in June Medical Services. So we must be honest about the impact of her passing and the impact it will have on the court's decisions in cases regarding women's access to reproductive health care. Now, my Republican colleagues have said that there is a minimal chance that the Supreme Court will overturn Roe. But back in January, 39 Republican senators, including 10 members of this very committee, signed their names to a Supreme Court brief that asked the court to, quote, take up the issue of whether Roe should be reconsidered and, if appropriate, overruled. So let's not make any mistake about it. Allowing President Trump to determine who fills the seat of Ruth Bader Ginsburg, a champion for women's rights and a critical vote in so many decisions that have sustained the right to choose, poses a threat to safe and legal abortion in our country. After all, President Trump said that overturning Roe v. Wade will, quote, happen automatically, in my opinion, because I am putting pro-life justices on the court. Judge Barrett, several times today, you have quoted Justice Ginsburg's testimony about not making predictions in future cases. However, she was far more forthcoming at her confirmation hearing about the essential rights of women. In 1993, Justice Ginsburg's confirmation hearing shows that she testified that, quote, the decision whether or not to bear a child is central to a woman's life, to her well-being and dignity. It is a decision she must make for herself. When government controls that decision, for her, she is being treated as less than a fully adult human responsible for her own choices. Then Judge Ginsburg went on to say, quote, it is essential to women's equality with man that she be the decision maker, that her choice be controlling. If you impose restraints that impede her choice, you are disadvantaging her because of her sex, unquote. Now, Justice Ginsburg did not tell the committee how she would vote in any particular case, but she did freely discuss how she viewed a woman's right to choose. But Judge Barrett, your record clearly shows you hold a different view. In 2006, you signed your name to an advertisement published in the South Bend Tribune. It described Roe v. Wade as, quote, an exercise of raw judicial power, and called for putting, quote, an end to the barbaric legacy of Roe v. Wade. You signed a similar ad in 2013 that described Roe as, quote, infamous, and expressed opposition to abortion. Also in 2013, you wrote an article about Supreme Court precedent in which you excluded Roe from a list of well-settled cases that you said, quote, no justice would overrule even if she disagrees, suggesting, of course, that you believe Roe is susceptible to being overturned. On the 40th anniversary of Roe, you delivered a speech in which you said that the court's recognition of the right to choose was, quote, created through judicial fiat, rather than grounded in the Constitution. And during your tenure on the Seventh Circuit Court of Appeals, you have been willing to reconsider abortion restrictions that other Republican-appointed judges found unconstitutional. As the Senate considers filling the seat of Justice Ruth Bader Ginsburg, who was straightforward enough in her confirmation hearing to say that the right to choose is, quote, essential to woman's equality, unquote, I would suggest that we not pretend that we don't know how this nominee views a woman's right to choose and make her own health care decisions. Mr. Chairman, I ask unanimous consent that the following 3 documents be entered into the record. A letter opposing Judge Barrett's nomination from the NAACP, a statement opposing Judge Barrett's nomination from the Planned Parenthood Federation of America and Planned Parenthood Action Fund, and a report opposing Judge Barrett's nomination from the NAACP Legal Defense and Educational Fund.
Without objection.
Thank you, Mr. Chairman.
Thank you. Thank you very much, Senator Harris.